My lords, my lady. 2 points of housekeeping. One, I understand from your clerk that you have received the other version of Wilkins and Rogerson.
Yes, we're grateful for that.
Second, just to say, we're doing fine on time.
Good.
Please don't hold back on any questions you may have as we go along.
We will not. Thank you.
We just finished the first tier decision. Say the questions in relation to the first tier is: one, is there an error of law somewhere in it? We say answer obviously yes. Secondly, is it material in the de Gore sense? Might it have made a difference? We say that there is that threshold is met in this case. You don't need to, if you don't want to, go into the question about how discretion comes into it. We say even if you were deciding the issue de novo, then the test is met. So now we're turning to the Upper Tribunal decision, which starts at page 69. So I'm going to try and run through the entire decision, just because the structure we say the Upper Tribunal adopted is precisely the correct structure. Looking at the FTT decision, finding is there an error of law, considering is it material, if it is, setting aside decision, then remaking the decision. That's the structure. That's exactly what the tribunal is required to do under section 12. So introduction, and then we have a reference to the legislation on page 71. Next, you have a recitation, paragraphs 11 onwards, of the facts. No one's taken issue with anything there, I believe. We can go to page 74. 29 is a summary of the FTT decision, but of course it's going to come back to look in a bit more detail when it comes to considering the materiality point. It notes in 29 the shorthand used, the reward or benefit point, quite rightly, it's very aware of that. And then refers to the ground of appeal, and then at 35, paragraph 35, page 76, we have the citation from the problematic paragraphs set out in full. And then from paragraphs 37 onwards we have submissions, and that goes all the way up until we get to page 89. All of that's been sort of summary and submission so far. Let me get to the meat of it. So my primary submission was that the overall conclusion of the FTT related to the loan because of the conflation in the final paragraphs that payment seems to include both. The Upper Tribunal disagrees with me, but of course that's not the end of the analysis. It then goes on quite properly, and so it still needs to decide the alternative point, whether or not the first tier erred in its reasoning to reach that conclusion in relation to the payment to the trust. Paragraph 87. So, quite properly, the Upper Tribunal, starting section 12, it's asking itself, is there an error of law somewhere in this decision? Paragraph 88, it identifies paragraph 37, which is the particularly problematic paragraph. Paragraph 89, HMRC's written submissions were based on this part of the FTT's reasoning not being of central importance to its conclusion. HMRC did not at that stage put forward any reasons why these paragraphs did not involve an error of law, the FTT. At the hearing, this prompted Mr. Elliott in opening to suggest that the revenue did not contest that these paragraphs involved an error of law. There's nothing in the revenue's written case trying to defend it. However, in oral submissions, it was said the revenues case for these paragraphs did not involve an error of law, with their alternative position being it was obiter. As set out more fully in our summary, Mr. Waldegrave's submissions was that whilst it was fact sensitive, a loan could amount to a payment of earnings, and the payment of the loan to Mr. Currell did amount. So this comes from the discussion yesterday. The Upper Tribunal has to address the question of whether or not the loan is earnings, because the revenue is saying that's not an error of law. And that's why we have this first section here. So, in a sense, it was the first time it had been argued in full, because it wasn't supposed to be an issue before the first year. Paragraph 90 is somewhat going to track what I'm going to say under section 3 of my submissions, which I'm going to come back to on loans. So there's the statutory regime. Paragraph 92, consideration of Rangers Supreme Court. Paragraph 94 to 95 considers the Rangers' decision at first tier and Upper Tribunal. We'll come and look at those, but it doesn't go a huge amount further than that, really. Paragraph 97, that the Revenue had not challenged the Upper Tribunal's reasoning in Rangers. They had changed arguments. And that the Supreme Court does not help HMRC in relation to the taxation of loans. All correct. Paragraph 99. We've concluded HMRC submissions in support of 33 to 37 are not supported by the legislative regime or the authorities, not only Apollo Fuels, but also the decision in Rangers. The reasons are given at 100. The primary reason is that the revenue submissions before the Upper Tribunal were not consistent with paragraph 37. Because the first two had said that in the vast majority of cases, whereas the revenue submission before the Upper Tribunal and before you, they say, no, we're not saying that in the most cases a loan will be earnings. So they weren't really trying to defend paragraph 37. But then, that's one. Then it moves to 2, and this is where the focus of the Upper Tribunal becomes very much focused on the facts of this case. And this is why we say that the Upper Tribunal did not say that a loan could never be earnings. And of course, once again, we need to look at the main decision. I believe that it actually says that in terms in its permission decision refusing permission. It's looking at the facts of this case. And in summary, what it says is that the revenue simply do not have the factual findings which could support any argument that the loan in this case is earnings. That's what's said at subparagraph 2. Then at 101, it confirms that Aberdeen Assets does not assist the revenue, the gloss of unreservedly at the disposal. The Upper Tribunal evidently has in mind that this is a loan. Fine, you've got the money until such time as it's called, but you've got to repay it. Aberdeen Assets was also distinguished by Lord Doherty in Rangers Upper Tribunal. We'll look at that later. Can't say that's an error of law. He said Aberdeen Assets does not assist the revenue in arguing that a loan is earnings. We will go to Aberdeen Assets and Garforth later. And the conclusion, 102, is very much the making of the loan was not a payment of earnings. So the focus is on this loan, in this case, based on these findings of the first tier. So It's a matter for you if you want to engage with the revenue for their policy objectives as to when and in what circumstances loans can be earnings. But I'm going to focus on the facts of this case. That's the conclusion of the Upper Tribunal. And that's why we say, when the revenue sort of made their ground with people saying, oh, it looks like the Upper Tribunal might have said that a loan can never be earnings. That's not made out. That's the error of law they allege was made. It's just not saying that. So, the Upper Tribunal has cited the right case law. It's looked at the factual findings of the first tier, and it's identified an error of law in the first tier's reasoning. So that's our first condition of section 12 TCEA. Now we move to apply, is it going to set aside the decision? And it turns to materiality. And it sets out divorce. Everyone agrees that's the correct test, no error of law there. And then it does the analysis that we've effectively just done for the short adjournment, going through the tribunal's decision and looking at how the conclusions at 33 to 37 interact with the ultimate conclusion. I don't think anything in that section is going to be surprising to you, because I'm making the same submissions as I did before the Upper Tribunal, which were accepted. And that leads to the conclusion at 109. We recognise that some of these points could be said to arise from too closer scrutiny, but the phrases in particular made above in relation to the use of it and its in 37. However, reading the decision as a whole, we have come to the conclusion that the error of law might have made a difference to the decision reached by the tribunal. We are particularly concerned by 44 and the way in which the tribunal explained its conclusions at 56 and 57. We have concluded the error of law is material, i.e. it might have made a difference, and that justice requires the decision be set aside. And that's applying divorce. That's why the threshold for setting aside is so low. There would have been nothing wrong with the Upper Tribunal saying, we think there's an error of law, we think it's material, and then going on to remake the decision and reach the same conclusion for different reasons. It could have done that, but it's adopted the correct approach, which is set aside a decision that has a material error of law and then remake the decision, applying effectively a de novo consideration of the principles as applied to the facts. So, the first tier has been set aside. And we say that's all correct for the reasons I gave before the adjournment. If you were with the respondent on my submissions made before lunch, that means that the Upper Tribunal becomes the primary decision in this case, because the first tier decision is of no, it doesn't exist anymore, save, of course, that the first thing the Upper Tribunal does, it says, well, of course, we're still going to use the primary factual findings. So this decision is the one that's under appeal. And if you were with us so far that it was correct to set aside the first tier, of course, your jurisdiction and powers under section 40 arise only if you find an error of law in the Upper Tribunal decision that we're about to look at. So paragraph 111 onwards to 117, there's a discussion about which facts are to be used. There is one correction to the facts you'll have seen about the payment movements. The tribunal decides it doesn't need to deal with my other point, that the money ended up with Mrs. Currell, not Mr. Currell. It says it doesn't need to look at that, so it didn't accept my point effectively on that. 117, we're therefore able to remake the decision on the basis of the tribunal's findings of fact are undisturbed, save in relation to the point it's just made, that it's made a correction. That's why I started my submissions going back to what the FTT findings were, because that's where the Upper Tribunal was considering as well. Paragraph 118, the Upper Tribunal identifies two issues. Is the payment an earnings? Is the loan earnings? Same issues as before you. It's already done the loan, but it says I'm not going to do that again. So the only question left for it is whether the payment is earnings. That's what it starts at paragraph 120. And as I said, the revenues submission at 121 is, as they apply, they say, well, this is a straightforward application of Rangers Supreme Court. Of course, the problem with that is, Rangers Supreme Court does not help them on the key question of whether or not the payment is remuneration. And that's what the Upper Tribunal says. So then it considers Rangers similar, because it's accepting my submissions, similar to what you heard from me this morning. Paragraph 124. The Upper Tribunal is acutely aware that the executives had no contractual right to their bonuses. That's set out at 124.3. The bonuses which RFC and the other employers gave their executives are made available through the same trust mechanisms. The employees had no contractual entitlement to the bonuses before the employers decided to give them. That does not alter the analysis of or the effect of the scheme. The fact that bonuses were voluntary on the part of the employer is irrelevant, so long as the sum of money is given in respect of the employer's work as an employee. For the same reason which caused the footballer's remuneration, the bonuses which were paid to the employees from the trust mechanism fall within the tax charge. That is all correct. The Upper Tribunal has stated very clearly it understands the executives are different in terms of facts, but as we saw from the Supreme Court, the analysis is identical because it's remuneration. This is going to inform when we get to the revenue's big line of attack in paragraph 127. It has stated very clearly it understands that point. Then we get to 125. The decision of the Supreme Court not only sets out the applicable principles, it also includes Lord Hodge's application of the law to the facts. However, the decision must be considered by reference to the issue. So that's the point I made this morning. It's the latter part of the decision. And Lady Justice Falk asked very reasonably, why is Lord Hodge bothering with that section? Well, and my submission is, he's identifying the points that justify the conclusion in that case that the payments were remuneration. It's not just the fact it's a bonus, it's the loans and it's the subtrusts. 3 reasons he gives at the end of his judgment. (126). The decision of the Supreme Court in Rangers. Supreme Court establishes that a payment to a trust or another third party may itself comprise taxable earnings in that amount. It is not precluded from being such by the fact the employee receives such amount from a trust by way of a loan rather than outright gift. However...
Sorry, can I just ask you about the first sentence? On your submission, is that an accurate statement of what the decision in Rangers decides?
As long as the word may is in there. And so, a payment to a trust may comprise taxable earnings. So and it says, to put it another way, it's not precluded from being taxable earnings by the mere fact that it's paid not to the employee but to a third party. That is the ratio of Rangers.
Well, I agree. I'm not sure that's what the first sentence is saying. This seems to be putting the weight in the last 6 or 7 words on the contrast between loan rather than outright gift, whereas I had understood your submission to be that the real burden of the ratio of Rangers is that as long that the employee doesn't have to receive the payment themselves, the fact that it's paid to a third party doesn't preclude it from being a payment of earnings. I'm not trying to make a point against you. If anything, it might be a point in your favour. I'm just trying to understand why they seem to place so much weight on. I mean, in your submissions, there hasn't really been much weight placed on the fact that there were loans in Rangers. Or am I wrong?
Given that it was an agreed fact that it was remuneration.
Yeah.
It would not have. It was not necessary for Lord Hodge to include that final section of the judgment. It could have been shorter.
No,
That's my reading.
I think we're at cross purposes. I really don't want to labour this. It probably doesn't matter. I was just questioning whether the first sentence of paragraph 126, never mind what Lord Hodge said, but the Upper Tribunal in this judgment appears to be giving prominence to a feature of Rangers, which I'm not sure is really central to the ratio of Rangers. Because it seems to me the central, never mind if there hadn't been loans, or the point that the fundamental argument in Rangers was, it's not payment of earnings within the legislation if the employee doesn't himself receive it.
Yes.
Yeah, and therefore what the ratio of Rangers is it doesn't matter if it goes to a third party.
That is the ratio.
Yeah,
I agree.
yeah.
That is the narrow ratio, certainly, of
Yeah,
range.
I think possibly, and because going back to those three reasons that we were debating why Lord Hodge included them, one of them does, or two of them do touch on the loans.
Mm.
Well, Lord Hodge thought it was relevant.
Yeah.
And in my submission, there is a certain amount of relevance. If you are asking whether something is remuneration, it is legitimate to think, well, what's the outcome of all of this going to be? And of course, the combination of the loans and the subtrust was that in each case, the payment, whatever it is, £10,000 is paid. In Rangers, it was going to inure permanently for the employee in two ways. One, they were going to have the money for the rest of their lives. And two, say after the end of their lives, or if they decided to make a repayment of the loan, it's still there for their benefit because it's in a trust and they decide who the beneficiaries are. So I submit on those facts, it is legitimate to look, what does the employee get right at the end? However, and that was, Lord Hodge clearly thought that was relevant. However, there was a shorter answer for him, which was, it's all agreed. These are bonuses.
Right, well, I interrupted you. You were citing from 126, I think.
Yes. So if we read that first sentence as saying, if the ultimate thing the employee gets is simply a loan, the employee directly gets, that doesn't stop the earlier payment being earnings. That's how I read, I may say that sentence. However, it was accepted by the taxpayer that the payments trust were remuneration for services provided by the employees, including the footballers and the executives. This is apparent from the summary of the taxpayer accounts as submissions, 34, I took you to that, where he was said to assert it was not sufficient that payment of money arises from the performance of the duties, and that a payment to a third party is not sufficient unless you have a legal right. And that's set out in the description of the issue by Lord Hodge. So far, you say so good. Then we get to paragraph 127. So this paragraph comes from an exchange between myself and the Upper Tribunal. And the Upper Tribunal was asking, well, there's this word entitlement. Lord Hodge has used it. What does he mean? And we discussed that, and this paragraph is where we got to. Maybe I should have just said, don't worry about it. But we did grapple it, and the Upper Tribunal grasps the nettle. let's say it ultimately accepted my submission, let's say it's right. The role then played by whether there is an entitlement to the remuneration is more difficult. Lord Hodge set out the issue at 1 as involving the circumstance before he had no prior entitlements, and then set out the general rule as being that the charge tax extends to money the employee is entitled to have paid as his remuneration. He was rejecting the Taxpayers' Council's submission that a payment to a third party can only be earnings if it has a legal right to receive the payment. The facts involve 2 situations. For the footballers, the focus is on the net remuneration. The side letter, there was thus a contract providing for the amount to be paid by RFC to the trust. Pause there. So far we've looked at the footballers. Secondly, the next says, there was no equivalent to this side letter for the executives. For those employees, Lord Hodge said there was no contractual entitlement to the bonuses before their employer decided to give them. So once again, the Upper Tribunal has recognised, as it said earlier, that there is no contractual entitlement. And when the Upper Tribunal is talking about a contractual entitlement, it always puts the word contractual in front of it. We saw that in the earlier paragraph as well. The Upper Tribunal recognises you don't need a contractual entitlement because that was the facts for the executives. So there is no possibility that the Upper Tribunal is going to find something different than what we're about to say. I know, I can see the question coming. Right.
They accepted. What is the nature of this entitlement?
What is the nature of this entitlement? And what does the word entitlement mean? Because it's not contractual. So what did Lord Hodge mean by entitlement? He must have meant something. He must just mean that the amounts were bonuses, i.e. remuneration, which the employer had decided to award through the trust arrangements. Now, contract lawyer might say, well, that's what I would call an entitlement. They say the Upper Tribunal uses the word contractual entitlement when it means a contractual entitlement. And they accepted this submission. We agree with Mr. Elliott's submission. That should not be read as saying there's never any entitlement at all, not contractual entitlement, just entitlement. There was no entitlement to these bonuses, that there was no entitlement to these bonuses which had been agreed upon, but I say the next
agreed upon engagement.
Engagement.
Yes,
is
they're then saying when their job started, they didn't have an entitlement.
Yeah.
When they were taken on.
Yes, but it doesn't then say, it doesn't say that a contractual entitlement arose later. It says during the employment, the employer decided. So I say the understanding of entitlement follows the word but.
Oh, yes.
But that during the employment, the employer decided to award the bonus and decided it was to be delivered through the trust arrangements. That is it. That is what the Upper Tribunal understands by entitlement.
It's potentially susceptible to the misinterpretation that it might mean that an entitlement, a legal entitlement, is developed by custom and practice over time after engagement, which you don't argue for. And at the moment, at least, I'm trying to work out, I don't think moral entitlement enters the picture. So what is the word entitlement?
Well,
It doesn't mean a legal entitlement.
let's remind ourselves of what we saw from the evidence of ranges. Because we had cases where the employer comes to the employee and says, well, I'm thinking of paying you a bonus of £50,000. You have no contractual right to that. You're never going to have a contractual right to that. I'm planning on putting it through the trust arrangement because you have to have acquiescence from the employee. So you've been told as the employee, I'm thinking of paying you a bonus of £50,000. I'm thinking of paying it through the trust arrangement. You give some form of acquiescence. That's what Lord Hodge says is necessary. Now, that doesn't create a contractual entitlement. It does create something, though. Create perhaps an expectation would have been a better word, maybe. Or a moral.
He's acquiesced in the payment.
Yes, an acquiescence. An acquiescence, maybe. But that is what the Upper Tribunal is getting. It cannot be saying that there's a contract, because it's said twice already that there was no contractual entitlement at all in relation to the executives. It can't be getting confused when it gets right to the end of that paragraph.
Well, I mean, more prosaically, it might be said that it's the Upper Tribunal having a go at trying to apply what Lord Hodge said at 41, which is quoted just above, which uses the term entitlement. That's one of the difficulties with
it is one of the difficulties, and I must say I
And
found
you
quite
may or
helpful.
may not agree with, well, may or may not agree with what is said at the end of 127, but I think it was touched on yesterday. In what way does this matter?
Well, that's going to be my alternative submission. My submission, though, is that there is no error in 127, be my primary submission, because the Upper Tribunal clearly understands that there is no need for a contractual entitlement, because it's stated it 2 or 3 times already. And then it stops using the word contractual, and it says, well, what does this word entitlement mean? And it tells us what it means at the end. It says that during the employment, the employer decided to award the bonus and decided that this would be delivered through the trust arrangements.
That either says too much or too little, I think. I mean, generally you can't pay something to someone as remuneration, I think, without acquiescence. I think you would be surprised to find if someone had put something into a trust in your name that you had no knowledge of because you'd done a very good job, suddenly you were taxable upon it.
Well, that's if it's paid for a third party. Of course, if you're an employee and you just get a bonus, you might find it in your bank account.
But with not returning that, there's a lot of law on payment. I think that is sufficient, or your bank account has standing authority to accept. But, so I can see that acquiescence is a meaningful requirement here. And I just wonder whether that's really what they had in mind.
Yes. Well, I say my primary submission. Obviously, my alternative submission is going to be it's not material, given it goes straight to the correct question. Is that the Upper Tribunal has understood if there is any meaning to be given to that word entitlement, it definitely isn't making the error that the revenue say it's making, which is that it's finding that there has to be some form of contractual entitlement. It's said repeatedly that's not a requirement. It accepts the bonuses but totally discretionary. It's saying, look, we need to give this word entitlement a meaning. Basically, it's being a bonus being paid by your employer, and that they've decided to pay, i.e., it's remuneration. Remuneration which you've acquiesced in having paid to a third party.
Can I ask you a very simple question, and my lord and my lady will know the answer to this, so they must forgive me for asking it. If you didn't have the interposition of the third party arrangement, you just have a payment of a bonus to an employee, is that taxable?
Yes.
Right. So the fact that you're not contractually or otherwise entitled to the payment of a discretionary bonus doesn't prevent it, A, constituting remuneration, and B,
Indeed.
falling into the earnings which are to be taxed. So is this a possible way of understanding all that Rangers is deciding? Is that if that's the case with direct payment to an employee, it doesn't matter that there's been a third-party trust arrangement interposed.
Because it's don't pay me, pay Aunt Agatha.
Exactly. Is that what it amounts to?
That's all that Rangers ultimately decide.
Well, that's what I thought.
And we say that's what is being. I say there's nothing inconsistent with that at the end of that paragraph, and I say also that 128 is not a non sequitur. But it then says it is not agreed this payment is remuneration. That's not starting a new topic. That follows on. Submits. To reach this, well, look, I've got to work out, says the tribunal, we've got to work out whether there's a bonus that's been delivered via a third party.
As I read it, again, correct me if I'm wrong, the structure of the judgment in these few paragraphs is that they've been making the point that in Rangers there was no issue between the parties, that it was remuneration. And then at 128, they're saying it's not agreed between the parties to this appeal.
Yes, you could say that 127 is sort of a digression, and then we come back to the right question. And that's why I say my alternative argument is, well, don't worry about 127. But what we know is that the Upper Tribunal is definitely not saying that you need a contractual entitlement to the payment, because it said repeatedly those were not the facts of those were not the facts of Rangers. So it cannot be making the error of law alleged by the revenue. It goes straight then to the question. One, two, eight. It is not agreed between the parties to this appeal the payment of remuneration for his services, and we reject Mr. Walgrove's submission. The appeal involves a straightforward application of the decision in Rangers. think that was also accepted yesterday by the revenue. It's pointed out, well, it can't be straightforward because you've got to decide whether or not this is remuneration. 128, it is not agreed, sorry, and then it says 129, the FTT is found, and then we have a recitation of some of the key factual findings. 130, we agree with Mr. Waldegrave. So this is the revenue submission. You've also got to take a look afterwards and take a look at the loan. And this is not radical, this is you've got to look at all the circumstances. However, and they say that includes looking that actually these in particular, given these transactions are pre-wired, the payment is made to make the loan. However, we conclude that these findings do not support a conclusion that the payment itself was money paid as a reward or remuneration for his exertions as an employee. It says we need to consider the full picture. So it's already set out some facts at 129. You could say arguably 129 is the key facts. It says, but we've got to look at the whole picture. Here's some more facts. Subparagraph 1, the Upper Tribunal summarises the cash flow. Doesn't say that's an indicator against the payment being remuneration, it just says it's part of the full picture. Subparagraph 2, the Upper Tribunal notes the Tribunal did not find that there was no expectation the loan would be repaid. Now, if we look at the end of Lord Hodge's judgment, he appears, or at least arguably seems to appear to say, that well, the fact the loans were never going to be repaid was a relevant factor. But whether or not that is a relevant factor, what the Upper Tribunal is saying is, it's not a fact in this case. That's what's been said in subparagraph 2. That is a factor that was taken into account by Lord Hodge. And that is just looking at all the circumstances. Where's the money ultimately going to sit? We know in ranges it's long-term loan, comes back to trust, which you effectively control through your protector powers. We say there's nothing wrong with subparagraph 2. Subparagraph 3, a relevant distinguishing factor with the footballers is that there's no suggestion the employer would otherwise have paid the amount as remuneration. Well, that is a relevant distinguishing factor with the footballers. But we know the Upper Tribunal knows, it's said it already 2 or 3 times, you do not need a contractual entitlement.
They seem to be making a slightly different point. You could almost number it number 4, that when you look at the net remuneration, my words, not theirs. I think that the point they're making is that the £800,000 is not in effect a substitute for what would otherwise be the net remuneration.
They are saying that, yes. So that's a distinction with the footballers.
Yes,
But they're not saying that they're not saying that that's a requirement.
No.
That's the key there. So that is a relevant point. Now, if you did have that, if it was a substitute or there was a prior contractual entitlement, then obviously that would be a powerful point in the revenue's favour. It's just saying, well, we don't have that.
Yeah.
So it's already said twice, you don't need a prior contractual entitlement. So those 3 points are part of the full picture. No error of law there. 131. Whilst not stated in these terms, it is clear that the FTT considered there to be a link or connection between the appellant's decision to make the payment to the trustee and his position as a director. That is evident from the tribunal's conclusions of the reason for the payment and the arrangements being pre-wired. The appellant knew that when it paid, the company knew that when it paid £800,000 to the trustee, amount would be lent, and this did in fact occur. However, the existence of such a link or connection is not sufficient for the amount of the payment to constitute the earnings of Mr. Currell. Has to take into account the character of what he received, namely the loan, and his resulting obligation to pay the loan. That's right. We discussed that in my part 2. For example, looking at something like Wilkins and Rogerson. Why is the payment being made to the tailor? Well, it's got a connection to employment. Of course, it's got a connection to employment. It's only being paid because there's an intention to reward the employee. That's not enough, though. This really goes to the big point in this case. Is it enough that the reward will ultimately have the character? They then sort of reverse engineers.
Again, forgive me for interrupting, Mr. Reddy. Again, it may not matter. It's not central to this appeal, but I'm speaking for myself. I'm slightly concerned about words like link or in connection with, because I'm conscious that, for example, that is the language of Part 7A, and we had to deal with this in Marlborough. The whole point was we drew a contrast in Marlborough between the usual language of tax law on earnings, which requires a causal link. Words like for or from employment have been used traditionally, and we drew the contrast that in connection with as a broader phrase than that. So I only wanted to enter a word of caution here that although I understand why the Upper Tribunal at 131, because it's really reporting what the FTT had said, considered there to be a link or connection. Speaking for myself, I'm not entirely sure that that's the right question in the context of earnings.
And that is what the Upper Tribunal is effectively saying, I suppose.
Right,
So
okay.
there is a link or, so you could say FTT said there's a link or connection. So obviously this,
Yes.
just jump aside for a moment.
Yes, I
If
see.
we were doing a Part 7A,
Yeah.
where there's a lower threshold,
Yeah.
maybe that would be enough. That's not enough for earnings though.
Yeah,
It's a
I see.
higher threshold.
see.
There's nothing wrong with that. So it's saying that's not enough. You need something more. You need to look at the character. It carries on. We have identified above the areas of key differences of the facts in Rangers Supreme Court being not only the agreement between the parties in the appeal as to the payments to the principal trust being remuneration, so that's the primary point, that's not agreed at all, but also the facts in relation to the side letters which were agreed alongside the employment contract, and the expectation that the terms of the loans would be extended throughout each employee's lifetime. They would only be repayable after their estate. Now HMRC say, oh look, it looks like it's referring specifically to the footballers. The executives aren't covered, but of course the executives are covered by the wording, the agreement between the parties in that appeal as to the payments of the principal trust being remuneration. That agreement extended to both sets of payments. It was agreed that the payment to the executives were remuneration. We saw that finding as a observation of Lord Hodge. So that was the agreed position in Rangers. That's a relevant point of distinction. So read as a whole, we say there is no error of law in the Upper Tribunal analysis, and therefore the revenues appeal must be rejected. So I've got two alternative submissions. If you think something went wrong in any particular sentence, or in paragraph 126, contrary to what I've submitted, we submitted had no bearing on the following paragraphs. Where
Sorry, you meant 127 then.
Sorry, 127, yes. Yes, I'm not going to start adding. 127 is the one that the revenue particularly attack.
Yeah.
Because it then, having done that discussion, then jumps straight to the right question, which is, well, was this payment remuneration? So I would be inviting you, I think we would be applying divorce again, to find that it was not material. It would, it might not. You should not find that it might have made a difference given the particular structure here. But of course, in the alternative, if you were to decide that actually the best thing to do is to apply your own minds, you have my submissions under Part 2. But applying the findings of fact of the first year, and you applying your own minds to this, there is no basis for concluding that the payment to the trust was remuneration. Because the only way the revenue can get there is through the reverse architecture. Payment is to make the loan. Loan is rewards, therefore payment is rewards. And I've made submissions to you that they cannot make good that that is not a good submission. That proposition of law is wrong. They have no support for it. And I've provided you some case law to get the opposite and some examples of the problems that would arise. Basically turning benefits which are generally taxed on a sort of yearly basis, loan interests, leasing of cars, accommodation benefits, into a one-off capital charge. So those are my submissions on the Upper Tribunal's decision. Before we move to loans, just wanted to address the revenue skeleton argument, paragraph 46. I don't think it was raised, but I want to make sure I've covered everything. It was the suggestion that the Upper Tribunal's analysis would lead to arbitrary distinctions depending on which meeting it was agreed the bonus would be paid. It's at Core Bundle 31. The short answer is we say that's not a distinction drawn by the Upper Tribunal. Of course, all of those situations are taxable. There are 3 scenarios given.
This all comes back to this question entitlement, does it?
Well, I just want to be clear on what our position is on these examples. 3 scenarios are given. It's suggested the second and third scenarios would not be taxable on the Upper Tribunal's analysis. Second scenario being the employer and the employee meet on the 1st of April and decide the employer will pay a bonus to the third party. Well, that's obviously taxable. It's remuneration. It's being paid. That's it. Third scenario being the employee might decide to pay a bonus via a third party and then makes the decision later. It doesn't make any difference. You've still got remuneration being paid. Both of those, we say, would actually fall within what's said in 127 of the Upper Tribunal. During the employment, the employer decided to award the bonus and decided this would be delivered during the trust arrangements. Something inconsistent with what the Upper Tribunal, all 3 scenarios fall within that description. So I just want to make sure we do not accept there's any distinctions, either based on what the Upper Tribunal said, but certainly regardless of what you think the Upper Tribunal said, we do not think there's any distinctions. All of those are obviously taxable. I'm now moving backwards, I'm afraid, to section 3, which is loans. So the revenues case, as I understood it from yesterday, is that where a taxpayer has practical control over whether or not to repay the principal of the loan, or they have an option to repay, that is earnings, provided that the loan is a reward for services. That's what I understood their submission to be. Responses. 4 responses. First, there's no authority for that proposition. It's contrary to Rangers, it's contrary to O'Leary. In fact, it's even contrary to their own guidance, I'm going to show you briefly. Second, it isn't consistent with the statutory scheme. Third, it's contrary to current practice, causes significant practical problems. Every day, directors draw on their directors' loan accounts with flexibility, potentially choice about whether and when they repay those loans. They have practical control over that. Revenues say, well, if you've got practical control, that's earnings. That's the submission they've made. It's bizarre. Fourth, perhaps this is the short answer. Even if that were the threshold, the revenue do not have the factual findings in this case to support that very low threshold.
Can you just remind me what your second point was?
Second point is inconsistent with the statutory scheme.
Right,
I think I'll have time to cover it briefly. Section 455, the code on loans,
Yep.
Potentially even part 7A when it comes in, of course, as well. I'll deal with the factual point first because that is our primary submission. I hate this case to go on to the Supreme Court just because there's another proposition that the revenue don't like, which they say applies to tens of thousands of cases. HMRC say, and they have to say, argue this, that Mr. Currell controlled whether or not he made repayment. And I asked rhetorically, where is that stated in the facts? Yes, he's one of the directors of the company, and he's a minority shareholder, but there was no finding that the company controlled the trustees, or that it wouldn't call, or the trustee wouldn't call in the loan or enforce it or anything similar. The only finding, one word they can attach, oh, well, it was said the trustee was reactive in relation to bonuses, not in relation to the loan.
It's common ground, isn't it, that the trustee is one of these third-party entities,
Yes, it's an unrelated third party.
called trustee.
Yes. And that's why we're very careful to make sure we didn't end up with sort of cipher arguments or arguments that they would do whatever they were told. And the revenue didn't get those findings. Now, so in light of that fourth point, you might decide to save this for a case where it actually matters. But just in case you do want to say something about this, I'm going to give you a bit of the background on the case law. I'm going to look at, we've already looked at Apollo Fuels, there's a bit more in there. O'Leary, Rangers, some of the legislation, then Garforth and Aberdeen assets at speed.
That's fine. It's a matter for you how you present your submissions, but I know that you'll finish by 3:30.
I will finish, I will sit down at 3:30. I may, at some point it might become paragraph references, but we'll see how we're doing. Unless, I mean, this is how I'm going to use the rest of my time, unless there's any other points. Court thinks, say, I've tried to take all my time on big points like the FTT's decision, whether there's a material error of law, and the big point from the revenue, which is their proposition that you can revert once you've got a benefit provided by a third party, then the payment that was made to that to provide that benefit it must be earnings, which is wrong. Those are the big points. If anyone thinks of anything, otherwise we'll look at loan cases. So 3 preliminary points. So we see the types of loans we are discussing are those where money is advanced on the legal condition the money be repaid. And there is a common intention the money will be repaid. Because if there is a common intention the repayment won't be made, then that is either a sham in the snook sense, or it's not a genuine loan, it's the second argument run in OCO by the revenue. It's sort of Antionades and Villiers' point. Say if the common intention is something different, it's not really a loan at all. So we aren't concerned with those types of loans, inverted commas. We're concerned with a real loan where there's a common intention the loan will be repaid. Second point, preliminary point, the confusion that became clear in the revenue submission was that their submission yesterday was, well, a loan is earnings, and therefore the question is whether or not it's been paid. Those are indeed the two conditions, but they're looking at the wrong one. Because what ranges the Upper Tribunal, the case law like O'Leary says, is not that the loan isn't paid, it says that the loan isn't earnings. So I'm afraid they've addressed you on the wrong condition. That's one of the reasons that Aberdeen and assets in Garforth aren't going to be very helpful, even if they were looking at loans, which they're not. And in fact, that's what their own guidance says. I'll briefly show you the revenue's guidance and what it says about loans. So Authorities Bundle 1270. So this is the revenue's current guidance, it's still published, on the General Anti-Abuse Rule, which sets out various transactions and explains HMRC's analysis of them. Page 127, that's 1270. The example we're looking at starts on 1272. 1274, which is, it's called D25A. I'm not going to make too much of this. It's only guidance. It's called RSP Limited Disguised Remuneration. I know it's only guidance, but we do have to think how the revenue submission before this court is actually consistent with what they say to taxpayers generally. So we have a description. You may want to take more time to sort of look back, but in summary, the employer is RSP. It establishes an EBT for the benefit of one director. The employer company contributes £1 million to the EBT. The EBT then used the £1 million to subscribe for shares in a New Jersey company, and then the employee borrows £1 million on the group company. So that's the loan, borrows £1 million from its employer's group. It's a group company of RSP. It's not from the employer, it's from another group company. Then the employee uses the £1 million loan to purchase the shares, and the group company issues loan notes. Outcome of these transactions, the employee has a loan from a group company, i.e. a third party, and the employer owes £1 million to the EBT, and then both of those loans are released. Obviously far more complicated than the straightforward arrangement in this case, but one of the key steps is the employee receives what is said to be a genuine loan from a member of the employer's group. Albeit, this is a scheme, there is a common intention it's never going to be repaid, it's going to be released. DA 25A.3, what's the relevant legislation? It's section 62 and the NIC legislation. D25A.5, what is the GAR analysis? HMRC accept that loans are not earnings as defined in section 3, nor general earnings as defined in section 62. And then they go on to say, well, the taxpayer's analysis is that Part 7A doesn't apply, etc. So even if it's a highly artificial arrangement, and there's a loan made to an employee, which everyone knows is never going to be paid because it's going to be released as part of the scheme, the Revenue's published guidance says that's not earnings. What that emphasises is 2 points. One, here the Revenue are actually asking the right question, is it earnings, not whether it's paid. Two, it's that what the Revenue was saying before you was actually quite radical. It's very radical. They're challenging the existing principles and even their own published position on how loans are taxed. Legislation on loans, I'll take this short. I think that the court will have a familiarity with this. You've got a specific chapter in the Benefits Code, but may I give you the page references as we go along? Would that be okay? It's Authorities Bundle 78. Chapter 7 begins with section 173. It applies to loans, i.e. any form of credit. And it's a very broad provision. Actually, I am just on this bit of legislation, I am going to ask you to tell it up actually. So it's page 78 is where it starts. Tab 9 is following in a hard copy bundle. So this is the start of the chapter. And then 173 on the, so that's 173. Loan means any form of credit. So it's not narrow to sort of banking lawyer might think of it as a loan. And it includes arranging, guaranteeing, or any way facilitating a loan. And what that means, of course, is if you make a payment to a third party so they can make a loan, that's facilitating a loan. So this regime would catch payment to a third party in order to make a loan. And then 174, which is on page 80, defines what an employment-related loan is. Note in particular A loan made by the employer. But made, we just saw defined, includes facilitating. So A would cover, once again, a payment to a third party. And then what you get at section 175 is you get the tax treatment, which is the benefit is basically the difference between the annual benefit between the interest, which is very familiar to my lady, obviously. So if the loan is £1 million and the official rate is 5%, and there's no interest, then the benefit is going to be £50,000 each year. And then sections 176 to 179 include exceptions. And all we note from that is, of course, Mr. Currell did fall within one of the exceptions. And the revenue have never challenged that. So there is, although this regime applies in principle to this loan, everyone agrees that actually there's no charge because we're within one of the exceptions, of the exemptions. So Parliament has created a specific regime to tax the benefit of employment-related loans. But it's created exceptions. You might think it was a bit strange if the Parliament had created specific exceptions to charge the interest. Somewhat undermines it if the first payment is earnings. You also have at page 105, which is section 188. So there is a time under this regime when the principal of the loan is charged, and that's where it's released. And I ask you to recollect what Lord Hodge said at paragraph 46 of Rangers, which is that where an employer spends money to confer a benefit in kind which the recipient cannot convert to money, that type of sum only falls within the income tax regime because of the benefits code. And he lists examples and includes loans. He said it only fell within the income tax regime because of this charge. That's consistent with the case law. Now, it might be possible, generally in the benefits code, for you to have something that could fall within the benefit, but actually it's earnings. An example would be something like Heaton and Bell. So Heaton and Bell, it was possible to convert the car actually back to salary effectively. So there was an earnings charge. And that is why, just to cover this point, although one submission's made on it, that's why you have section 64, which gives priority to an earnings charge. But there can be no, since that provision covers all the different types of benefits, there can be no implication from section 64. But therefore that means that Parliament intended that loans could be earnings. And the two other codes are the loan to participators regime, which my lady noticed yesterday was actually amended in 2013, would catch this type of arrangement in 2013. And then, of course, you've got Part 7A, which comes in. Part 7A does tax the principal of the loan. That was Marlborough, for example.
But again, that's not relevant at the relevant time.
It's not, it doesn't apply in this case. So then case law. We've looked at Apollo Fuels and the statements that, generally speaking, if you receive a benefit but you pay full consideration for it, that's not a benefit in any real sense. Now, of course, that's in relation to leasing cars. We say the same applies in relation to loans. If you borrow £800,000 of an equal and opposite obligation to pay it back, that's full consideration. Subject to the interest, that's the only bit you could think about. Of course, that's charged by the benefits code. If we could go, please, to Authorities Bundle 869. We've already looked at the start of Apollo Fuels where that bit's stated. 869. Just wanted to show you. The sideline passage is a discussion of the benefits code. And it's actually a discussion of the benefits code in relation to the loans, to chapter 7. It says, and in particular, whilst the whole passage may be worth sort of reading for background, it's paragraph 69 that's particularly relevant. Chapter 7 is a sophisticated set of provisions designed to deal with a number of situations. The main thrust of the chapter is to bring into charge to income tax, loans to employees which are beneficial to him in the ordinary sense of the word. And then it goes on to consider the charge by reference to the cheapness of the loans. A loan will be a cheap taxable loan if either no interest is paid for the relevant year, an obvious case of a benefit in the ordinary sense of the word, or if the interest is less than the official rate. So the benefit identified in the ordinary sense of the word by Lord Justice Richards is the lack of or reduction in interest. And he says it's the code that brings it into charge. So that's Apollo. We've then got O'Leary. O'Leary is at 571 of the authorities bundle. Might I ask the court to read the head note? See what the facts were in that case.
Sorry, which page is this?
Sorry, 571 of the authority.
57.
571, tab 25.
Yep, thank you.
So Arsenal lent the trustee an amount of money, and the interest that arose was given to the employee. Question, was the interest employment income under Schedule E? And the Special Commissioners in the High Court said it was. But what's relevant for our case is it's actually, until Rains's, one of the only cases which asks, well, how do you tax loans usually? And that discussion, it's at 575. And it's the Special Commissioner's discussion there. Yes. And I'm just going to ask you to note the Special Commissioner's. No, we'll go through it. If I could ask you to read that sideline passage.
So where am I reading from?
So at 575, the sidelined passage, might
Oh,
I
I
ask
see.
the court to read that, please?
Yes.
So 3 points to note. The first is margin letter C, is the Commission has accepted the taxpayer's submission that the making of the loan might be an emolument in principle, but it's without value, i.e. the principal of the loan is not taxable. And that is consistent with the discussion in Apollo Fuels, that even though, is the discussion sort of later on in the judgment, that even if something is derived from employment, it has to be asked, well, what does the employment get? What's the value of it? And the conclusion of Apollo Fuels is you can have earnings of nil. That's not earnings at all. Second point.
Can I just ask you to pause there? Again, forgive me for asking a very basic question. And others in this
If
court.
I may, my lord, I feel like we're asking, in this case, fundamental questions
Yeah,
rather than basic
well,
ones.
let me ask the question, and if it's a bad question, then we'll just move on. Leaving aside authority, and I know we can't leave aside authority because Apollo Fuels is Court of Appeal authority, so it's binding on this court. I understand that, but just trying to understand what's going on as a matter of principle. If you say, take my lord's example from yesterday about the season ticket, if you are an employee and you have to get to work on a commuter train and you have to pay for your weekly or monthly season ticket, unless somebody gives you a loan or someone else pays for it, you're going to have to pay for that out of your net earnings. yourself.
Yes.
So if it's more advantageous if you can get an annual ticket because pro rata is cheaper, and secondly, you can now afford it because somebody's giving you a very large loan to pay for that, whereas on your own you couldn't afford it. Why isn't that, at least in principle, capable of being expressed in some kind of financial value? You are getting
it is
something.
expressed in financial value, in that if there's no interest on that loan,
Yeah.
you're going to have tax under the benefiting kind provisions.
Yeah, but you showed us the cheap loans
Yes.
provisions. But what I'm trying to understand is why, if it's capable of being an emolument, why it's then said that it's an emolument without any value.
Because it's full market. It's full market value in terms of in respect of the principal.
Well, that would be for a loan repayable on demand, which is,
Unless you could turn it to account, but what can you
Yes.
make from the principal?
well, that's the point.
Yes.
That's the point I was about to make.
yes.
Tennant and Smith tells us that emoluments have to be things that can be turned to account.
Yeah.
So-
All right. Well, I understand. I mean, that's the law. I think sometimes people refer to the man on the London Underground who seems to have replaced the Clapham omnibus passenger. My wife says this is all very London-centric anyway. But what I prefer to call them the reasonable member of society. A reasonable member of society might think, actually, you are getting something of value, because otherwise you won't be able to get to
Well, you're
work.
getting something, because you might think, well, what is the benefit you're getting? If you couldn't possibly get your season ticket, that means you might have to go to a commercial loan provider.
Yes, exactly.
What's your loss then? What's your gain by getting it from the employer? Well, it's the interest you would have had to pay, but that's not actually. Maybe that's the common sense, but the tax way of looking at it is: what can I do with my loan? I could put it in my bank account, which is a loan, credit, or I could loan it to someone else, and I could turn interest on it.
Yes, that's very.
That's
helpful.
the benefit.
No, I understand. It's
And that's-
it's enlightened me, so it's helpful, but it's a bit of a digression. So
it's fundamental. That is, that is why I show you earlier, because there's no many cases. You then get the High Court at page 579,
right.
and if I might just ask you, I might, if it's okay, ask you to sort of read that in your own time. But it basically says the same thing. The point being that if there's an emolument, it's nil. There's definitely no emolument on the principle, because of, this is why I started with Tennant and Smith. The principle is sort of how we value the benefits, the emolument in respect of things like loans. Rangers first tier and Upper Tribunal, we're going to take very quickly because we've already done all the facts. So it's authorities 642. Just going to show you the passages.
642.
642 in tab 27. Apologise,
Do you have a
haven't
paragraph
given-
number?
We're looking at, so decision of the majority, it starts at 186.
Yeah.
And you can see the issue at 186. Essentially, the issue before is whether the term earnings extends to the loans. And the conclusion is at 655, page 655. There's a long discussion ending with the sideline passage of page 6. And then we have the Upper Tribunal at 794. Lord Doherty. And just as you read this, Lord Doherty is not saying there are earnings but there's no payment. He's saying there are no earnings. So even though we went through all the findings earlier, that these loans were never going to be repaid during lifetime, they were a revolving facility, going to burden the estate, etc. You could unscramble, etc. That's the finding in the Upper Tribunal. The revenue did not appeal that aspect. They appealed the overall decision. The revenue have to grapple with this if they're going to make their submission, and they haven't yet. That is the most recent sort of lead authority on loans, and they did not challenge it. They changed counsel, they dropped the argument on the loans, they abandoned it, and they swapped to a different argument. And yet they come before you, ironically sort of upside down, that they say that before the first tier they weren't arguing it, and they're picking it up at third tier. Whereas of course in Rangers they argued it for the first tier and then dropped it.
Well, if it's a good argument, it's a good argument. And as I
If
said
it's a good
yesterday,
argument, it's a good argument.
the function of this court, particularly because we set binding precedents, is to get the law right.
Indeed.
However, the
But the
argument
revenue
has
do
come
need to
to us.
grapple with my submission. This is the most recent
no,
case
no,
looking at loans.
yeah.
They have to grapple with that.
Yeah,
They haven't addressed it.
I understand that your argument is that on its merits it's a bad argument, and we'll have to grapple with that.
They have to say that it was wrong. And also, maybe not now, but there is also Lord Doherty distinguishing Aberdeen assets at the next paragraph. So in your own time, perhaps that's
65.
It's 65 to 66.
Right.
So Aberdeen assets doesn't help is the headline there. So we've seen the line of case law. Genuine loans with real repayment obligations are generally not taxable as earnings, because a loan is given the full consideration in regards of its principal. It's only the interest, if it's below market value, that you might say it's turned to account, or that it might be taxable under the Benefits Code. And you've also got, of course, that comprehensive code put in place by Parliament, which is really undermined by the revenue submission. Garforth and Aberdeen assets. Actually, we'll come back. I want to do ochre, actually, tough glaze. So
Where are we now?
tough glaze we're going to. So you have that loose, I believe, or in your emails. Headline points. This decision was not relied upon by HMRC before the first tier or the Upper Tribunal. As HMRC accept, the actual decision of the first tier, in tough glaze, was that the payment to the sub-funds was earnings. The comments on the loans is obiter. You might also take into account that both parties cast doubt on the whole reasoning of tough glaze, given it seems to have misapplied the redirection argument. And this is another case about bonuses. You can see that at paragraph 3. So it's very similar to Rangers. But all I want to do is show you how the first tier reaches its conclusion. The attack on the loans is at 337, paragraph 337, that is. And it's a short section because the tribunal has already reached its conclusion on the payment to the subtrusts, but it says, I've heard full arguments, so I'm going to make the decision. It says that at 336. And the key point is at page 192, it's the final sentence of 342. So well, this whole section, which has been sidelined, is worth reading. While it's insufficient to infer there was an agreement not to seek repayments, consistent with the finding there was no realistic prospect, it seems clear to me that if a repayment demand was made under the agreement and the loan was not repaid, there would be no issue in enforcement. That's the last 3 lines of paragraph 342. So, finding of fact, if the trustee tried to call in the loan and the employee said no, the trustee wasn't going to enforce it. We have nothing like that. I'm not here to tell you that OCO in that respect, that it's impossible for a loan of that category maybe to be treated, albeit perhaps the right analysis might be more like sham or Antionades and Villiers.
Sorry, which areas?
That a payment like that,
Yeah.
loan payments where there's no the common intention is it's not going to be enforced.
Yes.
I'm not here to say that's not earnings. I don't have to say that.
Yes.
Maybe in that extreme situation, maybe the correct argument is more like sham or Antionades and Villiers.
I see.
I'm just wondering if that last sentence of 342 bears the construction contention. I mean, there's a finding that highly unlikely the trustees would seek repayment unless it was wanted by the borrower. But isn't that last line saying if that happened, there would be no issue with enforcement of the loan? The loan was accordingly a true loan. Maybe to the opposite sense. I suspect it's the back end of 343 that's talking about.
Well, yes, it's highly unlikely it would be enforced. So maybe read them together. I'd say the finding there is that it's highly unlikely that
Well,
the loan is
it's unlikely to be demanded.
which can be demanded or
Can't be
enforced.
enforced without being demanded.
Yes. So that we're nowhere near that. No. And then all I was going to say on Aberdeen Assets and Garfield is that when you look at those cases, in both cases the taxpayer actually accepted that the payment was in principle taxable. In fact, we go to this. Page 564.
Page 5.
564. But in particular, it's 565. It's the second sideline passage. It's where Mr. Kronigsberger, who appeared for the taxpayer company, accepted what appears to be the true position, namely at the end of the tax year, a proper assessment could be made on the directors to the extent that POE deductions had not been made. So except there is earnings here. The question is it assessable directly on the directors, or is it collectible under PAYE? Because it's a payment. The issue being, is there a payment? And that you see that in the opening words, if we go back one page. Walton, this is Mr. Justice Walton, the case raises the short but difficult point as precisely what is meant by the word payment. Same point for Aberdeen Assets, which we've already seen distinguished by Lord Docherty in Rangers. And the page reference for that is 741. Sidelined passage, and it's paragraph in particular 34. Where you see on page 752, which is in considering what amounts to payment for the purpose of the PAYE legislation. That's the issue in that case. It's not about earnings. So they address a different question, and they're definitely not about loans. So just two final points just to conclude all of my submissions. So some other sort of sense checks. There's been discussion about whether there could be a Ramsey argument in a case like this, because it's a pre-wired transaction which results in the employee receiving a loan and nothing more. We submit an assent check. It is not therefore surprising that the correct tax treatment of that transaction, pre-wired transaction, is to tax the loan. What would be surprising is that all an employee is getting is a genuinely repayable loan for 1 year, 2 years, 5 years, is their tax as if they've got an outright payment even though they've got to repay it. The second point, I think we've already touched upon, is I'm going to title Judicial Intuition, or Man on the Underground. if this court thinks that HMRC's outcome is counterintuitive, because, for example, it results in fundamental differences in taxation, depending on, for example, whether the benefit is provided by the employer or there's a payment to a third party and they provide the benefits, or because it cuts across the statutory codes, the respondent urges you not to fight that instinct, because when it comes to the taxation of earnings, application of common sense and judicial intuition is encouraged. See Lord Hodge in Ford and McHugh, and or Justice Richards in Apollo Fields. May I just take instructions for a moment? Unless I can be of any further
Thank you.
assistance
No,
to
check
the
if there are any other questions. Thank you very much. Yes, Mr. Go.
Thank you very much. Grounds, I'll deal with grounds 1, 2 and 4. That's distilled actually into one issue, one question. Is that payment remuneration? Now I know that's the question the FTT asked. That's the question that the Upper Tribunal addressed, because it is now conceded, as it has to be, irrespective of the terms of this loan to Mr. Currell. If that payment of 800,000 is remuneration, that payment is taxable as earnings. And in my reply, I'll deal with the points raised by the respondent as to why it is that they're wrong to say that this payment isn't earnings. But one point up front, please. There is no express finding rejecting the proposition, the factual submission, that this payment was earnings, was remuneration. There can't be, because if there had been, we have no case. So it was wrong to categorise what the FTT found on the facts as declining or rejecting the proposition that that payment was remuneration. We search in vain at in paragraphs 15, 16 onwards for any such finding. That's wrong. Now about remuneration, we know the test: reward for services, remuneration, quid pro quo, words of that nature. Some points and rangers in response. And these are points which I want to make now, and they're important points in the course of my response. One, I showed this court yesterday, paragraph 39 and 41, when my Lord Hodge used the word entitlement, because he was talking about the footballers. There really isn't a problem. There really isn't a difficulty. Because what he does, my Lord Hodge, is he deals with the footballers, and then in a separate paragraph he says, at 31, before he gets to analysis, look, the executives are the same, and then at 66, at the end of his analysis, look, the executives are the same. So I don't accept there's any difficulty in applying rangers, and in particular, looking at that word entitlement as used by my Lord Hodge at 39 or 41. The footballers did have an entitlement, and that's what he was speaking about. It could hardly be simpler. 2. Why did my Lord Hodge even mention the fact of the loans, the fact of the subtrusts? And that's because of 2 reasons. 1, until the case had reached the division, all the focus, you've seen it, over and over and over again in the respondent submissions was that all the employees had received were loans, and that's how it was put by my Lord Doherty, replicating the language of the FTT. All they received, use that word, all they received, all they got was a loan. And that's not earnings. And although the argument changed in the division, the Supreme Court was perfectly alive that it had to deal with, this was a high-profile case. I mean, to those who care about tax. This was a high-profile case where what was being put against me was, in a world in which employees end up with just loans, come on, how can you tax them on the payment in? So he had to address that, because he had to address also the second point. I said there was 2 points he's dealt with these loans. What's the difference? Because what was said against me, both in the division and in the Supreme Court, was it's an EBT. What's wrong with an EBT? It's normal. No, this wasn't a normal EBT. A pre-funded EBT is where employer companies, or any employer, puts money into an EBT ready for the trustees of that EBT to appoint out to employees as and when a bonus committee or remuneration committee decides. And that was not the Rangers case. It wasn't just a normal EBT. And what paragraph 61 is doing is the Supreme Court doing its job to say, we're giving you guidance as to what remuneration is. It doesn't change if it's paid to a third party. It's agreed that this payment in is remuneration. You can't say different for the footballers or the executives. And by the way, lighten up. This is not driving a coach and horses through normal commercial arrangements. So there's no mystery about paragraph 61. Now, remuneration, what is it? This reward for services. This is going to deal with all the examples put to you by the respondent about the benefits code and how the revenues argument is all terrible. No, the cases like Wilkins and Rogerson, the employer spending money, the employee ends up with a suit. What the court has to grapple with, and I remember this conversation very well because I was having it with my Lord Newburger. This is really a question that is more likely than not to be resolved at FTT level. Is what the reward is it money? Am I paying you £1 million to buy a house, in which case your earnings are £1 million? The benefits code's got nothing to do with it. Or is your reward the house? In which case the benefits code takes over. And everyone recognises that that question might be controversial. And to find the answer to that question, this question is that payment, in this case, remuneration. One has to look at everything. A mixed question of fact and law. So nothing in what I, or indeed Mr. Aldergrave, said yesterday drives a coach and horses to the benefits code. That is simply wrong. One does have to grapple with, and in this case, whether there's a payment of money or the reward is something else, something other. Now in this case, that was put to you over the course of today repeatedly, the money was to fund the loan. That's what the FTT found. That's literally half the story. Because what the company also knew was that the earnings would be utilised through the share acquisition. So, access £800,000 from where? The company. At a time when Mr. Currell, not just Mrs. Currell or Mr. and Mrs. Currell together, there's a finding, it's at 3613, that because of the acquiescence of Mrs. Currell, Mr. Currell had unfettered access in the FTT decision. When Mr. Currell wanted it and the company can afford it, have this 800,000 in a world in which he was under-rewarded for work. It is a most unfair gloss in my submissions to say, well, this is our funding for the loan. Come on, what's the revenue playing at? This is funding to access 800,000 tax-free to Mr. Currell in a world in which he was under-rewarded. That's what this pre-wired scheme did. And that's why it makes all the difference, not just a difference, all the difference. Narrative here is everything. How you look at this scheme. It is a scheme. Tax advice. The acquisition of shares just to avoid the cheap loan scheme, the cheap loan provisions. So it's a scheme, all right. Is this scheme just to lend money to Mr. Currell? Of course not. It's not a season ticket loan, that's the point. It's a loan to access 800,000 tax-free.
Mr. Ghosh, forgive me, I'm struggling to see why that extra element needs so much emphasis, because if the scheme had stopped without the money going back into the company, Mr. Currell would still have had access.
That would be true, my lady. But when I'll tell you now, and then I'll return to this point. When Mr. Elliott was objecting to the so-called reverse engineering, the purpose of the loan was a reward and benefit, therefore the purpose of the payment was a reward and benefit. That takes even more colour, even more weight. It is even more obviously correct because of those the third and fourth elements, that he was going to buy shares and then he was going to get access to this 800,000. That's the reason I'm emphasising this. If the scheme had stopped at the loan, it would have been like Rangers. They could buy yachts, they could buy whatever they wanted. This went further. This was the employer company knowing, I am making this payment to the EBT so that you, Mr. Currell, end up with a world in which you can take 800,000 from me, the company, tax-free. That gives weight to the notion that payment is a reward to make up for his previous under-reward. It's not just a payment for a loan. What we're interrogating, what we're looking for, is an analytically sound description of what that payment is. It's either a kind of, it's a payment to fund a loan, nothing more. It's got no other relevance to the tax code. Or it's what I'm saying it is, what the revenue's saying it is, which is a payment of earning salary. Because the company is assisting you, Mr. Currell, to take out 800,000 from me tax-free. And as I say, there may well be other cases where a tribunal or a court, including this court, is to grapple with, are you getting a car or are you getting money? Are you getting a house or are you getting money? Have I given you £1 million to buy a house, or am I giving a house worth £1 million, in which case the benefit? Well, that's not this case. This case is money. The only question is it earnings? It's step one of the scheme that buys you access to £800,000 tax-free in a world in which you've been under-rewarded so far. Is it correct? Is it analytically sound? Common sense, intuition, you can pick whatever word you like. This is rewarding you. And I'm saying, yes, of course it is. One point that's mentioned by my Lord Justice Singh yesterday to me, it came up again in the course of the respondents' submissions, that this money wasn't a substitution. I said yesterday, so what? That wasn't being glib, I was being analytically correct. There are at least two ways that money, well, Section 62 tells you there are three ways, there are three heads where money can be remuneration. One is contractual or voluntary, or bonuses, the work I've done. Or it could be a tip, forget tips. Or it could be money not from my employer, but which replaces earnings, an insurance policy, something of that nature. That's the substitution principle. There are squads of cases on it. My Lady Justice Falk will be well aware of them. Thames Haven and Apple, cases like that. But the substitution principle has nothing to do with this case. And that's why I said, in response to my Lord Justice Singh, they wouldn't have paid this absent scheme. I don't care about that. They're rewarding him because he's not been rewarded yet. They wouldn't have paid salary. I don't care. They found a way to get that to him tax-free as and when he wants it, and the company can pay it. For what? Work done. And that was acknowledged even by the Upper Tribunal. That's why, my lady, I pay heavy emphasis that the loan wasn't, you can't just stop at the loan. The company knew what that loan was going to be used for. Then I get on to this point about reverse engineering. Do you mind, please, if you have a look? What is it? I want to look, please, at 27 and 28 of the first year decision.
What page is that?
I'll find it, my lord. It's 140. And it's just to let you know, reverse engineering, well, you can be as pejorative as you like, but what the FTT is saying at 27 and 28 is, the evidence here is sparse, it's a mess. We have had to make our finding with inferences. And there's nothing wrong with that. So it's not reverse engineering, because fast forwarding to 56 and 57. This is exactly the exchange I had with my Lady Justice Falk yesterday. 56, they say, we've got two things to say at 56. The payment was made to fund the loan. The loan was paid as a reward for services. We infer from that that the payment was a reward for services. And the question here is whether there's an error of law. They can look at the law, there's no error of law there. There's an error of law in 56 and 57 because of what they said in 33 to 37. That's exactly how I put it to this court yesterday, and in reply, this way of putting it wasn't addressed by the respondent. I'm saying, does 33 to 37 infect the inference made in 57 from what they say in 56? And in my respectful submission, the answer is no. Why? There are passages in 33 to 37 we don't defend. Vast majority of loans count as benefit. All that. But a loan can be a benefit, and this loan is a reward or a benefit. And we've got the respondent saying in this code, in principle, that is possible. They've acknowledged that.
Sorry.
Yes, ma'am.
Yesterday, I think you were suggesting that sometimes where the FGT used reward or benefit, they weren't using it in the
And
sense that they defined it.
I maintain that. I'm simply saying,
So you're saying they found that the loan was a reward or benefit in the non-technical, non-defined sense. You maintain that submission.
I do, and I say that must be right because there's only one. This isn't a game,
Yeah.
and there aren't two tax charges. They found that the payment was a reward or a benefit. They've done that. If they had meant that the loan was a reward or a benefit in the section 62 bracket taxable post bracket sense, there would have been another tax charge. And there isn't one. Nobody's saying there's that. They're not saying that. And there were, you know, the level of scrutiny on the FTT's approach, it has to be the same scrutiny in the Upper Tribunal's approach. That's just something I want to trail. But they cannot have meant that there is a charge on the loan under section 62. They're saying there might have been, but there is no charge on their finding in this tribunal decision because the charge is on the payment. But what they have done in 57 is infer that the payment was a reward for services, for work done. And I'm saying they had more than enough material for that. You either look at this scheme, and you say it's the trustees it's the company funding a loan. That's the beginning and the end of it. That's not earnings, or it might be, but it's not Rangers because of the Rangers. The facts were different, and all Mr. Currell's ended up with is a loan. Or you say, well, no, that's not the full picture. No, it's not. Plenty of material to make an inference that because of the features and the circumstances of the loan, the payment is itself a reward for services. And my Lady Justice Falk has say so, absolutely nailed this point. I do say, and I do maintain, that when they use the word reward or benefit, it can't have meant of the type that incurs the charge under section 62, because otherwise where is the tax charge? It's not a rhetorical question, where is it? One small point, then I'll find it. Yes, in the course of the company's submissions in the FGT, please can you tell me what the references for the accounting, that the money for accounts purposes is still in the company? Well, I'll give you the reference in a moment if I may. But during the course of the company's submissions in the FGT, they said, well, this money still as a balance sheet item in the company. That's because of accounting practice. So the company can't claim a CT deduction, because you can only claim a CT deduction when there's an accounting debit in the profit and loss account or some other income statement. Everyone knows that. And if it was a genuine fund, you're going to need EBT, they would expect a deduction, whether or not it was salary to Mr. Currell. So that shouldn't be taken as some sort of badge of innocence on the part of this taxpayer. I will find it before I complete my submission as to where that's made. Oh, paragraph 21, subsection 15. Could you give me the page, please? Yes, you're hearing Mr. Waldron through my mouth, but 139. Oh yes, there it is. Thank you very much indeed.
Sorry, subparagraph.
15.
Thank you.
So that's all I want to say about the FTT, at least on grounds 1, 2 and 4. There's loads of material that this payment isn't funding a season ticket, any of that. There's an under reward. Is that payment a reward for work done? Yes, because it's saying we can't pay you now, but you can get this money tax free as and when you want. You, not even you and your wife, you. That's the finding of 3613. And that's the case. Whatever you might take about this point about the loan being paid or not repaid after 5 years, and whether it was the reason or a reason. I've got my submissions, I won't say them again. I don't accept the only thing stopping repayment was the tax. That's not a safe basis, given that they say one reason later on. But that's not going to win or lose a case, you'd otherwise win or lose. We do know that tax considerations means that this loan has not been. Know that. So it's not, this isn't 5 years versus only repayment on death. That's not the contrast. The contrast is a loan with 5 years. If there's a problem, we're not paying that. That's a different kind of loan. Now, while I'm at it, the CIA strategic branding, and with the permission, I won't show you, you've seen it again, but I would please ask the court to look at these passages in their own time. Because what the learned judge did there, what the first year tribunal did there, was precisely the exercise carried on by the first year tribunal and the upper tribunal in Rangers. They said, look, the FTT in both cases said there is a link, and I'll come to the observations made by my Lord Justice Singh about be careful about the language you use. But there is a link or connection between the payment into the trust and the loan. And in CIA and strategic branding, I mean, the court will have better things to do this time, but if you read it, the recipients of those loans were not going to be paid back anytime soon. There were findings of SHAB in strategic branding, but not for everything. No findings of SHAB in CIA, but they bought jewellery, cars, houses. But what the FTT did, you've seen it twice now, which is why in the course of my reply, unless you need me to, I won't show you again, but it's there for you to see. The reasoning by the FTT is pure FTT Rangers reasoning. There's a link or a connection between the payment into the trust and work done, that's true, but they end up with real obligations. That's why my Rangers submissions failed. That can't be right. That's not a non sequitur. That's what they say. And you can read that without any gloss put on it by me. There's a relevant link or connection between the payment and work, but because the loan attracts genuine obligations in those cases, that is sufficient to make the payments not earnings. I showed you yesterday. I showed you the whole thing. And I invite the court to reread it, as I say, with no gloss put on it by me. That was my complaint yesterday. That's pure Rangers FTT. And my submission was, we're in a post-Rangers world now, and I'm saying if there's a connection...
So you say Rangers FTT, but you mean Rangers Upper Tribunal as
well?
well,
FTT and Upper Tribunal. That was exactly. FTT and Upper Tribunal. The Upper Tribunal simply endorsed the FTT at paragraph 64, which you see, and they said there was no error of law, because all they received was a loan, and that's got real obligations. But I wasn't arguing that.
And just to be clear, the reason why that you say pure FTT or UT ranges is you say that doesn't take proper account of what then happened in Ranges Supreme Court. What is the burden of your point?
It's quite simple, really. I say that one my point is that if the reason that the payment was made was a quid pro quo for work done, that payment into the trust is earnings. And the fact that it was then lent, so put in one way, all the employee got was a loan with real obligations, doesn't stop the payment being earnings.
Thank you.
That was literally all I was advancing in Rangers and what I was advancing here in CIA and strategic branding. Literally. And to say, well, the loan's a real loan, that means that the payment isn't earnings. That's it's like Rangers was never decided in the Supreme Court or in the division. That's why this case is so important to the revenue. That's why it's so important that if this point gets traction at tribunal level, it needs to be sorted out. And that's why, can I show you please? Oh well, just while I'm at it, just to pick up one point. So I've said, before I leave the FTT decision, well, I accept the FTT at 33 to 37 went too far when it talked about vast majority of loans being benefits. Paragraph 44, that's just wrong. I can't defend that. But does it infect the inference? That's the question. Did the conclusion that the payment was earnings in the inference made at 57, is that infected because of those errors? In my submission, the answer is no. Then looking at, please, the Upper Tribunal 6, divider 6, and just picking up something, please. 126 to 131. That's because we know they're saying that the Upper Tribunal have said we're leaving the findings of fact undisturbed. Their words at 117. So 126. There's some discussion between this court and Mr. Elliott. Speaking for myself, I don't have too much difficulty with the first sentence.
Okay.
But it's 127, starting there. Now this is the point, because Mr. Elliott said, the Upper Tribunal was careful to remind itself that the executives had no contractual right. So 1271 asks, well, what's the point of this discussion about what entitlement might have meant? And the response was, well, it might have been a diversion. Well, it's the same question that being put on the FTT. Well, you've gone into a diversion. Has it infected your position? Now, 128 says, well, the parties don't agree whether this is or isn't remuneration, bearing in mind that at 57, it says in terms the payment was a reward of service, a mixed finding of fact and law. So know that we've got a prior question. It's not a distinguishing question from Rangers, it's a prior question. Do we have remuneration in the first place? And that's why asking the this and 129.3, the only reason for the trustees making this loan was because of work. Only. So the inference from that finding should be that the payment, just about that, that proposition I've just delivered to this court, that because the loan was only for work done, there's an inference that the payment was for work done. That's not a function of analysis. I don't need a case. It's a function of dealing with evidence. That's what an inference is. I don't need a case that says if 2 happens after 1, that can tell you something about 1. As it happens, everybody accepts that. It's a curious submission that our submissions were deficient because we didn't have authority. We don't need authority. It's how you deal with making inferences. But at 1:30, having acknowledged that the only reason for the loan was work, they still say, the Upper Tribunal, that the findings do not support a conclusion that the payment itself was money paid as a reward or remuneration. And the question has to be why not, given that the payment was funding the loan. It has to be why not. It has to be, is that. It's not for me to show in the light of what's just been said at 129. It's for me to show that the payment was a reward. That ship sailed. We're in a world in which I know the payment is funding a loan. I know the loan is going to give tax-free access to £800,000. Why isn't that payment a reward for services when you've been under-rewarded so far? What's the full picture? Number 1, the appellant, as the company, continues to have use of that money. Do you see that? That the Upper Tribunal says that. At 1:30 little 1. Please does the court see? Where's the observation that the taxpayer has got, sorry, not the taxpayer, Mr. Currell, has got tax-free access? That comes at 2. He acquired shares, but an obligation to repay. Well, we know that, but so there was an obligation to repay in Rangers. There was no expectation that the loan wouldn't be repaid at term, but renewed. And that's why is that relevant? And then they acknowledged that the money could be taken out by Mrs. Currell, but the finding at 3613 of the FTT was that it was Mr. Currell, just him, that had unfettered access. Mr. Currell was under-rewarded. Now, looking at these 3 component parts of the full picture, where is any acknowledgement that there was this tax-free access mechanism? Otherwise, what's the point of this scheme? And where is the acknowledgement when they say there's no expectation that for tax reasons the loan wasn't repaid after 5 years? It's an incomplete picture. So that's why I'm saying that narrative here is everything. It's how you look at this picture. So while at 131, when the Upper Tribunal says they're considered to be a link or connection, the only, I said this to you yesterday, but I'm saying this in response. The only reason for the loan, on any view, was work. That's a finding of fact, not disturbed. And the only reason for the payment, you can't just stop at the loan. The company also knew the rest of the picture. And that's why it's this next sentence, which is, I said it was about analysis. The existence of such a link or connection, that's a connection to work, is not enough for the payment to constitute earnings. Because the first sentence is that there's a link or connection between the decision to make the payment and the directorship, not the loan. That first sentence focuses on the directorship, not the loan. But that's not enough, they say. Because why? And it's CIA and strategic branding literally replicated here. It takes no account of the character of what was received by Mr. Currell with the obligation to repay that loan. So we're absolutely into Rangers FTT, Rangers UT, all he received was a loan. No. What was done was a payment to get him tax-free access to £800,000 in the company. Now, to pick up a point raised more than once by my Lord Justice Foxton, the diversion at 127 about entitlement. Now, let's be clear, at 127, the Upper Tribunal said they agreed with Mr. Elliott that the Supreme Court was not to be read as saying there was never any entitlement at all. So he must have been saying there was an entitlement of some description. He must have been, otherwise that sentence makes no sense. And my Lord Justice Foxton says, well, where does that come in? Here it is. There is a key difference with the facts and Rangers. All right. There's a prior question about remuneration. Side letters for the footballers. On no view is this overture. The Upper Tribunal, and certainly the revenue, if this court disagrees with what I've just said, and no view is that overture, then of course I invite questions from this court. Because it says in terms that it's a key difference from Rangers. And then the expectation of that the loans wouldn't be repaid until death. How long does the deferral have to be? And where is the acknowledgement that the loan has not been repaid because of tax reasons? And in this full picture, as I've said, at 130 and 131, there is a literally complete absence that what was bought was tax-free access to 800,000.
Does the issue of expectation and its relevance fall to be tested at the point the loan is made?
I don't want to commit myself to an answer for all time coming. That's the obvious time to test it. Because what you're then looking at, what you're allowed to look at and must look at, is in a world in which payments being made not to you but to somebody else, an EBT, and all you're going to get from the EBT is a loan at present, why, in making a mixed finding of fact and law, is it correct to describe juristically that payment as your earnings? And one of the things you can look at is, am I happy that I'm getting this loan in this term? The Rangers footballers, because Rangers is a big company, they wanted side letters to say, you've got to make that payment. The executives, they didn't have that side letter. The expectation, that's why Lord Hodge, I think, was telling us all about what was going on in Rangers at paragraph 61. He said, in that world, where there was an expectation right from the start that it was only the loan would be repayable only on death, you shouldn't be surprised that they were happy with that. But he didn't need to say that as an analysis of why that made it remuneration. That ship had sailed. It was agreed to be remuneration, but he was explaining to the world reading his judgment. That doesn't surprise us.
But when you keep stressing that as we sit here now, the loan has yet been repaid apart from the 50,000. But in terms of the position at or around the date of the payment into the EBT and the loan being advanced out of it, what we know is it's 5 years, and we have a later finding that either the or one
reasons 5 years on why it's not repaid at that point is tax. Do we have anything there from which one could appropriately infer an expectation that it would have been outstanding as long as it has been, as at the date it's made?
Just by the fact that it has been. Nothing more, nothing less than that. And that's not a bad inference. That's not or you could take no inference. If this court were remaking this decision, this court must put such weight as it thinks is correct on the fact it's not been repaid, but it hasn't been. And what he was buying, it was put to me yesterday, what he was buying, Mr. Currell, was his access to this 800,000. And that wasn't a time-limited facility of 5 years on no leave. Because I was asked more than once, what is the other reason for not repaying the loan? What other reason did the FTT find? And you're right, I didn't put this as a reason, but I'm giving it as a reason. It's the
I asked the question earlier and you answered it. I have to say I'm finding it quite difficult to understand what the buying access to tax-free cash adds to the loan, possibly the purchase of the shares from the wife. But if the scheme had stopped there,
at which point?
selling the shares,
From
buying the
Mrs.
shares
Currell.
from the wife and not putting the cash in, he would have had access, precisely as you put it there, to 800,000. I think you're trying to, by that focus on that, perhaps take away the focus from the loan and any obligation to repay the loan. But I don't really see how it helps you.
No, I'm not, my lady. I'm not taking away focus from the loan. The loan was the payment, and then the loan was a step to give Mr. Currell what? He doesn't want. He passes 800,000 to his wife, but the company needs the money. He can't afford to pay. That could be another inference. But one way or another, we know the scheme wasn't that £800,000 leaves the company and immediately and stays with Mr. Currell. That wasn't the scheme. That was something that I've just shown you. The company needed that money back as working capital.
But to what extent then does that help you? Just going back to the man on the underground, might think, well, he hasn't had any money. Money's just gone round in a circle.
The money is there for him and the company can afford to pay him tax-free in a way that it couldn't before he'd done this scheme.
That's a different benefit.
The question is, that's the benefit he's bought. What does that tell you about the payment of the 800,000 to give him that benefit? Was that earnings? If this court, if I am paid salary in order to give me a super benefit, which is in the future, I can take that benefit as and when I want it. That is what tells you that payment to me is earnings coming from the company as a reward for services where I've been previously under-rewarded. So of course it helps me. I don't need help. You need to see the full picture. The company pays 800,000 for what? Loan, then acquisition for shares, but the company wants that money back. But back now in circumstances where, because it's lent back to the company, that 800,000 is ready and waiting for Mr. Currell when he wants it and the company can afford to pay him. What does that tell you about the status of that initial payment of 800,000? The company has paid me money to get me a benefit which will fructify in years to come because I've been under-rewarded so far. They hoped it was tax-free, but it's not because it's earnings. No different benefit. They paid me salary, call it what you want, a bonus, that they hoped was tax-free, that I could engineer with that money by taking the loan, getting shares from my wife, getting her to lend the money back to the company, that same 800,000 tax-free as and when I want it. What does that tell you about that initial payment in the first place of 800,000? Answer, it's an alienation of funds.
No, Mr. Ghosh, I have an eye on the clock.
Yes, and but nothing. I will finish by 4:30. So, if that submission fails before this court, then I can't help you, because the 800,000 is paid in order to, in a world in which I'm under rewarded, to let me get access to that same £800,000 later, as and when the company can actually give it to me in pound notes. And that's why it's important that you don't stop at the loan. And the acquisition of shares is just to beat the cheap loan provisions. So that's why narrative here is everything. It's not a season. It's not a season ticket loan. And I'm really not going to take too long on ranges, but I hope this court has now got this point as to why the reference to the side letter at 131, looked at in combination with 127, is clearly an error of law. It's not a diversion. 127. It's described as a key difference. Now, I'll finish on, please may I finish on loans. So, we have a world in which everyone, including the respondent, accepts that a loan is but a loan, can be an emolument in principle. You've actually got that recorded. It's concession by counsel, but it's recorded in Uliri. You just saw that, Mr. Flesh. Do you remember? The reason that this is all very difficult, and you've got the benefits code, is that it's difficult to value. I mean, Lady Justice Falk is of course right that if I borrow 100, that loan doesn't necessarily have no value. But that depends on the interest rate, it depends on the all sorts of things. But the big message in O'Leary was, look, a loan can be an emolument. This is a funny point to address this court on, because we've got findings. If I was pushed, if you're pushing me, now I'm on our ground 3, you've got the FTT saying in terms that loan was a reward or benefit, because respondent was rude about our submissions, saying we showed you Godford, we showed you Aberdeen Asset, they deal with payment, they don't deal with earnings. An accident. That job's been done by the FTT because they say in terms. If you think I'm wrong, that all of that learning in 33 to 37 was overture, it's a very funny point, a curious point to be arguing in front of this court. But if you think I'm wrong about that, they found, on the basis of factual findings in which there's no Edwards and Bairstow challenge, that loan was a reward or benefit. The only question left is payment.
And here you're using reward or benefit in the defined sense.
I have to, because here I'm saying I'm wrong about that. That exactly, of course I am, because that's the whole point of our ground 3.
I just wanted to make absolutely sure.
Well, no, I mean, you've got me. but yes, absolutely I am. Because this only arises if I'm wrong on my primary point.
Yeah.
So, absolutely, ground 3 only arises if I'm wrong about my primary point. And that means I lose on ground 1. My Lady Justice Falk is not just right, she's got to be right, of course you're right. So in that world, where they're using reward or benefit in a section 62 ought to be taxed sense, so there should be a tax charge. That what's been done by the FTT, so the only question left is payment. And I think my Lord Justice Singh asked, well, it's a just one way of putting it, but if you're wanting the kind of intellectual joy of knowing when can a principle of a loan ever be an emolument or benefit, answer wouldn't. It's not just a question of opportunity cost. I've got my employer lends me the money, so I don't have to go to a bank, and so it's the opportunity cost of the interest. Loans in foreign exchange can of course give rise to massive benefits. Actual benefits. There used to be a scheme years ago called the Zimbabwean dollar scheme, because the Zimbabwean dollar scheme, if you lend me money in Zimbabwean dollars, give it a week and I don't give you anything. There's one terrible, I think, year when they did it with Turkish lira, but everybody did the scheme, the Turkish lira actually went up. Anyway, that happened. But there are occasions in which you, going back to section 62(2)(b, the principle of the loan can confer tangible benefits. So grant fee is a real question, and as I say, it is, I accept, a point of curiosity to be addressing this court on this basis, because I'm addressing this court on the basis that I'm wrong about my explanation of 33 to 37. But in that world, everyone accepts a loan can be a loan in principle, and the FTT has made findings. And so the only question left is please, may you give me a moment. Those are my submissions.
Thank you. May I check if there are any other questions? No, we're very grateful not only to the advocates from whom we've heard, but for everyone in this case. We will reserve our judgments, and they will be circulated on the usual confidential terms. And I must stress the importance of respecting the embargo on the confidential draft judgment when it's circulated. This court will take very seriously if there is any breach of that embargo. I also stress that it's not an opportunity to argue the case again. It is an opportunity to tell us if we've got some facts wrong or made some typographical errors. Thank you very much.
All right, is able.